arbitration is a concept which has evolved with the flux of time. We've all seen that how the acts have evolved, the Arbitration Act of 1940, and thereafter the amendments in the Arbitration Act, and then evolvement of the Arbitration Act 1996. And as they say that the legal journey also evolves, the sections are interpreted in different ways. And we have seen larger aspects of law which have evolved as to what is the effect of curative petition, what is the scope under Section 34, Section 37, what is the scope of Section 11. And there are too many judgments. We thought, why not have a capsule of a judgment? And we also realized that there was none other person who's better than Mr. N.L. Rajah, a senior advocate from Madras High Court, who has done various sessions with us on different perspectives of law. Mr. Rajah is also very closely associated with Mr. Palkiwala's Arbitration Center. They did a course also. So we are so glad that Mr. Rajah has accepted to share his knowledge on some interesting recent judgments on arbitration. Being a weekend, we will not take much time on the introduction when Mr. Rajah is there, who's such a familiar face, not only in India, but across the globe. Over to you, Mr. Rajah. Thank you for sharing an invite.
Thanks, Mr. Vikas, for giving me this opportunity once again to share my thoughts on a topic which is very important to practitioners of law currently. I'm also thankful to you for starting this at 6, because if we had started it at 8 because of the India-South Africa match, we wouldn't have anybody tuning in. What I propose to do, if you had seen the caption to this presentation, I'm talking about some recent interesting judgments in the arbitration regime, and that is part 1, because there are so many interesting judgments that it is difficult to sort of present all that in one go. Arbitration is a very fast evolving field, and unless a practitioner of law in arbitration keeps abreast of the developments of the law and familiarizes himself with the recent judgments, he may face embarrassing situations in the court. Therefore, the idea behind this presentation is to tell you about the latest developments in the law, and importantly for you to know what should be the proper methodology, procedure, and the route that you would have to adopt to ensure that your petitions are not thrown out of court, they are taken up for consideration, and that you are able to present the law, because all of us as officers of court have a duty to present the correct position of law when a particular case is taken up for arguments. And therefore, there is an inherent responsibility of all of us to ensure that what we present is the correct position in law. And frankly, let me tell you, that's not a very easy challenge as far as arbitration field is concerned, because the law itself keeps changing on a day-to-day basis. So there is a responsibility for all of us to know that we are in fact presenting the correct position in law. Now, having given this basic idea of what I will be doing in this presentation, since we are talking about judgments, obviously judgments are precedents. And precedent is a previous instance or case which furnishes an example or rule for subsequent conduct and a pattern upon which subsequent conduct is based. This is one of the very simple definitions of a precedent. And therefore, when you cite the case law, you must ensure that you read the precedents carefully and match it with the case that you are doing in court, so that what you present is credible to the court. Now, you know that every decision has 3 basic postulates. The first is findings on facts, both direct and inferential. So this is the first part of a judgment. As practitioners of law, we know that a small difference between the facts in one case and in another can make a sea of change in respect of the legal outcome of a particular litigation. So you need to be very careful to appreciate in the first place, learn and familiarize yourself with the facts of your case thoroughly, and then look at the case that you intend to cite to ensure that you are not off the track as far as facts are concerned, and that exercise has to be done at the initial stage. The second is you will have to look at the case law that you intend to cite and look carefully at the statement of principles applicable to the legal problems and as disclosed by facts. So, what are the legal principles that have been applied to the facts in the case which the particular decision is dealing with? That inquiry by you is very important. Third is that the judgment rendered on the basis of the above are the ratio. You must understand that the judgment rendered on the basis of the above two alone are the ratio of the judgment. And therefore, there is a responsibility on you to appreciate what the ratio of the judgment is before citing a judgment. Therefore, when having appreciated these three aspects of a judicial decision, the next responsibility on the legal practitioner is to check the facts to see if they are in pari materia, then to check whether the law for which you intend to use the precedent is a ratio or an obiter. You can't cite everything that is stated in a judgment. A judgment is only an authority for what it seeks to decide. Many judges, while delivering judgments, may also talk about a whole lot of other things. But these really are not the ratio of the judgment and are termed as obiter. There's no point in citing an obiter, which is not part, it does not form part of the ratio of the judgment, because that's not going to help you further your cause in the litigation before the court. The third requirement is to see if the judgment which you intend to cite has been overruled. Now, that's a very, very important responsibility on the legal practitioner. Because today, as I said, since authorities, the shelf life of authorities in arbitration law is very, very limited, it seeks to get overruled very quickly. Therefore, it is essential for you before you cite a particular proposition to show that it is not be, to ensure that it is not be overruled, because otherwise you will look quite pathetic in court when the other side pops up and says, I'm sorry, this judgment is all very good, but then it's been overruled by a subsequent judge. So there is a responsibility on you to check. These are quite easy these days. When we started practice about 30 years back, this used to be a Himalayan task. How do I know? Then you will have to look at all the, for example, if I take a section 8 in an arbitration conciliation act, then I would have to sit and look at, pull out physically every volume and see whether this has been overruled. If I want the latest judgment, because once again, commentaries on law, treatises on law, supplementaries which they bring out on law will possibly will help you only till about a few months back or when that edition was brought up. But if you want the latest, you will have to do a lot of research, you will have to do backbreaking work. Now, with the infusion of technology into legal practice, all that is now available literally at the click of a mouse before a computer. So you will have to ensure that a particular authority that you propose to cite has not been overruled, and it is still current law, valid law, and you can with authority assert and ask for the acceptance of that judgment. Then the fourth is you have to check to see if the precedent which is against you has been rendered on legally sustainable principle. Now, this is very important. It doesn't happen so frequently. You see, law is not a profession which teaches you to answer questions. Law is a profession which teaches you to question answers. So look carefully. For example, in the Madras High Court, there was a proposition, there was a position in law which said that there is a presumption in law that all temples are public temples. This proposition held good for a good period of 30 years. Till in 2000, early 2000, a division bench questioned this proposition and said, from where do you get this? This doesn't flow from the provisions of the Hindu Religious and Charitable Endowments Act. It doesn't flow as any as a established provision of the common law. So therefore, from where do you get this provision, or where do you get this principle that every temple is supposed to be assumed to be a public temple? So like this, very many times in law, there are propositions which have ruled the field for ages together. And if you are convinced as a scholar of law, as a practitioner of law, and a person who has been applying the law to cases for a long period of time, you are convinced that this is not right, that this goes against enacted provisions of the law, this goes against Supreme Court judgments, but this has not been observed, then it is your responsibility, and you have a right to bring it to the attention of the court and tell the court that, listen, this appears to be a law which appears to be binding, but I don't think it's right. It appears to have been passed in complete ignorance of an existing provision of law, or it has been passed in ignorance of a binding judgment. If you bring it to the attention of the court, then there are various paths which the court will take. If it is convinced that there is a binding legal provision, it can even go to the extent of saying that the precedent is a per interium. And if it is convinced that the earlier judgment has been passed, ignoring another binding judgment of a coordinate bench, then it can request for that matter to be referred to a larger bench. So these are options available, and therefore do not sit back and say, oh, this case is against me, and therefore I don't think I have a very bright prospect in a particular case that I'm handling. That may hardly be the case, because if you take care to ensure that you look at the fine print of the law and do a diligent and thorough study into what the legal principle is and its application, then that precedent which is against you may not be the end of the road, and you can pursue the matter further. So these are some certain principles on which it is advisable for you to proceed to appreciate the precedents that I'm going to talk to you about. Because all these interesting cases that I'm talking to you about have sort of rewritten the law, or rather widened the prospect of the law, or have set a new path for the law to travel, which is important for a practitioner in the field of arbitration to notice. With this brief preface, let me go into the first case, which has garnered a lot of attention in recent times. All of you will know about the order that was passed by the Supreme Court, curative petition, setting aside an order that was passed earlier by the Supreme Court. This has caused a lot of heartburn. It has caused a lot of interest. It has evoked a lot of curiosity about the extent of the Supreme Court's jurisdiction in a curative petition. And this case is Delhi Airport Metro Express Private Limited versus Delhi Metro Rail Corporation, which is reported in 2022, which was earlier reported in 22-1 SEC 131, but has now been subsequently revisited. Now, what happened in this case? In this case, a three-judge bench of the Supreme Court of India, while deciding a curative petition in Delhi Metro Rail Corporation Limited versus Delhi Airport Metro Express Private Limited, set aside an arbitral award on the ground of patent illegality and perversity, recognized as grounds of challenge under Section 34(2)(a) of the Arbitration and Conciliation Act. The course which this dispute took is quite interesting. It started with the termination on October 23rd, 2012. DMRC, as we shall refer to the Delhi Metro Rail Corporation, initiated arbitration proceedings after exhausting the pre-reference mediation stipulated in the agreement. Now, this was pursuant to the termination of the agreement by DAMEPL on October 8, 2012. The matter was referred to arbitration, and in August 2013, a three-member arbitral tribunal was constituted. The tribunal then passed a unanimous award in favor of DAMEPL, and it gave various reliefs under the award. Since we are only going to be interested in the legal position here, I am not taking you through the finer aspects of what the award itself said. The short point, therefore, is that this order was in favor of DAMEPL. Now, a Section 34 application to set aside this award was filed before the Delhi High Court, and a single judge of the Delhi High Court dismissed the Section 34 application. Which means what? Which means that the award came to be recognized by the court and was held to be valid. Now, that is not the end of the story. There was an appeal filed to the division bench of the Delhi High Court under Section 37 of the Arbitration and Conciliation Act. As you all know, that under the provisions of the Arbitration and Conciliation Act, against an order passed under Section 34, an appeal would lie under Section 37 of the Arbitration and Conciliation Act. So, an appeal was filed before the division. The division bench set aside the award. It allowed the appeal against the order passed in an OP. It allowed the appeal and set aside the award and said, set aside the on grounds of perversity and patent illegality. Against the orders of the division bench, a special leave petition was filed before the Supreme Court under Article 136. A two-judge bench of the Supreme Court allowed the SLP and restored the award. So now what has happened till now? There is an award that has been passed. The award has been upheld by a single judge. A division bench has set aside that order and set aside the award. An appeal against the division bench order went to the Supreme Court. Supreme Court allowed the appeal against the order of the division bench, which means that the award revived. Now, all things would have been left there, but for the fact there was a curative petition filed before the Supreme Court contending that certain important aspects relating to the case had not been taken note of in the case. Therefore, the Supreme Court proceeded to hear the curative petition. On the first issue was the jurisdiction of the Supreme Court, while deciding a curative petition, extended to cases where the court had acted beyond its jurisdiction, resulting in a grave miscarriage of justice. So, was this an appropriate case, especially in an arbitration regime, especially in a domestic arbitration, for the Supreme Court to take up and hear? Now, this was the first question which the court had to answer, and the court answered the question in clear terms, saying that there was a miscarriage of justice, and therefore the court was keen on reopening the matter, hearing it, and passing orders. In respect of the facts of the case, the Supreme Court concluded that the two-judge bench of the Supreme Court erred in interfering with the decision of the division bench. While holding so, the Supreme Court concluded that the decision of this division bench was based on a correct application of the test under Section 34 of the Arbitration Act. It was further held that the decision of the division bench provided adequate reasons to come to the conclusion that the award suffered from perversity and patent illegality. Inter alia, the award overlooked crucial facts, the award overlooked the express terms of the contract, and therefore the award was not sustainable. So now where does that leave a practitioner of law in the field of arbitration? Now, clearly, the principle that flows from this is that there is a remedy available. It is very, very difficult to get the Supreme Court to open its doors on a curative petition. As we all know, that this jurisdiction of the Supreme Court was a jurisdiction which the court gave to itself, and subsequently the rules relating to filing of petitions before the Supreme Court were amended to provide for a provision where a curative petition could be filed before the Supreme Court, but with this caveat that the court would entertain such application and pass orders in the rarest of rare cases. So the Supreme Court considered that this is a rarest of rare case and decided to reopen the case and passed an order setting aside the award. It resulted in a loss of about 8,000 crores to DAEMPL, but that did not deter the court from passing this. Judgment has come up for some sharp criticism. There have also been people who have supported this judgment, and they have said that if the facts of the case warrant that the ultimate aim of the judiciary is to ensure that justice is being done in a particular case, and if the facts of a case warrant that there must be an interference on fact, then the court is bound to do it. Interestingly, there is a analogous provision with respect to curative petition is not something that is applicable to the High Courts, obviously, because it's part of the rules of the Supreme Court. But in the High Court, you have the power of review. And then there was a very interesting question which the Supreme Court decided quite some time back in the case of Jaya Chandra Mohapatra versus Land Acquisition Officer, which is 2005-9 SCC 123, where the Supreme Court said that there is a provision for even a second review. Let's assume that against a judgment which has been passed, you file a review petition, and that review petition comes to be dismissed. The provisions of the CPC only prohibit a review being filed against an order passed in a review petition. There is no provision of the CPC which prohibits you from filing a second review petition. This is the principle which the Supreme Court accepted and laid down in 2005-9 SCC 123. So this curative petition business, this facility of filing a second review petition are all facilities available in law to ensure that there is no miscarriage of justice. So that is the important concept, the principle of law, which is upheld through this judgment. Now, the second judgment, which caused a lot of interest and provoked a lot of debate for a long time until it has recently settled down, is the judgment of the Supreme Court, which it has titled. This is also a sort of a curative petition, except that it was referred to a larger bench, and therefore the bench gave its judgment. The judgment is titled In the Interplay Between Arbitration Agreements under the Arbitration and Conciliation Act 1996 and the Indian Stamp Act 1899. So the simple question before the court was, if you have an arbitration agreement and that arbitration agreement is part of a mother agreement, so to say, and the main agreement ought to have been stamped, but it is not stamped, then is that arbitration agreement valid and can it be invoked for referring the matter to arbitration? Now, this proposition of law traced a zigzag path for the last nearly 13 years. First, in SMS Tea Estates Private Limited versus Chanmari Tea Company Limited, the Supreme Court held that if a document containing an arbitration clause is found to be unstamped, insufficiently stamped, the arbitration clause embedded in it cannot be acted upon under Section 35 of the Stamp Act. Now, this is where the controversy first started. This judgment of the Supreme Court was followed, approved in the judgment of the Supreme Court in Garware Wall Ropes Limited versus Coastal Marine Constructions and Engineering Limited. This was in 2019. In this case, the Supreme Court reiterated the stance of the Supreme Court in SMST and held that an arbitration agreement in an unstamped instrument does not exist in law. It's void. You just can't rely on it. Thus, it cannot be acted upon by the courts at the time of appointment of an arbitrator. Now, after that came the first of the trilogy of NN Global case. In the first NN Global case, the Supreme Court rejected the law established in SMST and in Garware Wall Ropes with the conclusions. It held that an arbitration clause in an unstamped agreement or insufficiently stamped agreement would survive and it can be acted upon for the limited purpose of referring the matter to arbitration. So the reason behind this is that since arbitration agreement is an independent agreement between the parties, and the provisions of the Arbitration Conciliation Act itself say that an arbitration agreement is to be severed and to be treated as a separate agreement, this arbitration clause will survive the disqualifications which the main agreement itself has incurred. Now, this judgment led to the matter being referred to a larger bench because the Supreme Court was not satisfied with the ratio of this judgment. This is what I told you sometime earlier, that if you are satisfied that a particular proposition of law has not been decided on proper grounds, you have the power to persuade the court to refer it to a larger bench, which is what happened. And therefore, in Global, the first of the three judgments got referred to a larger bench. A five-judge bench of the Supreme Court went back to the SMST provision, and it held that Stamp Act was indeed a fiscal measure to protect the interest of revenue and was not to be used as a weapon by a litigant to defeat the case of the opponent. However, this was not sufficient reason to prevent the implementation of the Stamp Act, including the requirement of stamping at the time of execution of an agreement. The court said that an unstamped or insufficiently stamped agreement is legally unenforceable as it cannot be used as evidence for any purpose, and since a contract that ceases to be enforceable becomes void under Section 2J of Indian Contract Act 1972, an unstamped or insufficiently stamped agreement is void unless subsequently validated by payment of stamp duty. Now, this once again got referred to a larger bench of the Supreme Court, which is a seven-judge bench. The Supreme Court in this case first discussed the Stamp Act. Now, what is the objective of the Stamp Act? What does it propose to do? Now, which defines the word instruments, and Section 3A of the Indian Stamp Act provides that every instrument mentioned in Schedule 1 to the Stamp Act is chargeable with stamp duty of the amount indicated there. An arbitration agreement, being in the nature of an agreement and not specifically provided for in Schedule 1, would therefore fall under such a residuary category of, and accordingly has to be stamped. So in respect of the first question, Supreme Court said arbitration agreement has to be stamped. Second, it discussed the consequences of non-stamping or inadequate stamping of an agreement at different stages of the arbitration proceedings. It said that under Section 9 of the Arbitration Conciliation Act, a court can grant reliefs under Section 9 even though the agreement is not properly stamped. Then, ultimately, the court held that agreements lacking proper stamping or those with inadequate stamping are not inherently void or unenforceable from the beginning. Instead, they are deemed curable, that they suffer from a curable defect. Notably, objections related to stamping do not come under the purview of Section 8 or 11 of the Arbitration Act, which is the threshold entry barriers. It does not come within the jurisdiction of the entry barriers envisaged under the provisions of the Arbitration and Conciliation Act. But then, the issue does not stop there. It said that any objections concerning the stamping of the agreement fall within the jurisdiction of the arbitral tribunal. Consequently, the rulings in NN Global 2 and SMST estates were overturned. At this point of time, I need to point out one thing. There might be a question that, all right, an arbitration act has not been, the arbitration agreement has not been properly stamped. Let us assume that that arbitration agreement requires registration and it has not been registered. Now, what is the effect of that? Now, SMST itself has decided that question, which has not been revisited by the Supreme Court. SMST says that if there is any clause which could be construed to be a collateral purpose, and that is not part of the main agreement, the lack of registration will not affect the referring the matter to arbitration, will not in any way impede the right of the court to refer the matter to arbitration. So here is the resulting picture. The resulting picture is when there is an agreement which ought to have been registered, which is not registered, but there is a clause, an arbitration clause, the fact that the main agreement has not been registered will in no way impair the reference of the matter to arbitration. So let's get a registration out of the way. As far as stamping is concerned, now after NN Global, the 7-judge bench, the same logic applies. that this is not an entry barrier to having the matter referred to arbitration. The matter could still be referred to arbitration, but please remember, for practitioners of arbitration law, in respect of both, these are issues that you can place before the arbitrator and call on the arbitrator to decide the rights of the parties based on the fact that a particular document which ought to have been registered, or which ought to have been stamped, or which ought to have been stamped and registered has not been, the requirements have not been fulfilled. Now, this therefore is the resulting scenario, and practitioners of arbitration law must not think that just because the matter is referred to registration, it can take off from there. For example, if you have an unregistered document and the rights of the parties flow from that unregistered document, it is still possible for you to assert before the arbitrator that none of the rights which are being asserted by a party can be looked into, because all this flow from an unregistered document. Likewise, in respect of stamp duty, if the stamp duty has not been paid, it is possible for the party to assert that the stamp duty has not been paid, call on the appropriate authority to impound the document, levy the proper stamp duty, and assert before the arbitral tribunal that the arbitral tribunal can look at this document only after the deficiencies in the stamp duty have been addressed. Therefore, neither the judgment in SMST nor the judgment in NL Global, which is a 7-judge judgment, must lead a practitioners of arbitration law to think that because the Supreme Court says that the matter could be referred to arbitration, these issues are irrelevant in the arbitration proceedings. That's not right. The scene has only shifted from the court referring the matter to arbitration to the questions being agitated before the arbitral tribunal. So these are two cases which have attracted the attention of the legal community in a large measure. Now, let us come to a third very interesting, this question hasn't reached the Supreme Court yet, but it's a very interesting question, and already there is an appeal pending before the Supreme Court. The question is this: under Section 29A of the Arbitration Conciliation Act, which was brought into the provisions of the Act pursuant to the amendments in 2015, the timelines run like this. Under Section 23(4) of the Arbitration Conciliation Act, the pleadings, which is your claim, the counterclaim, rejoinder, everything has to be completed within 6 months of the arbitral tribunal or the arbitrator entering into reference. That is the first time. Now, after that starts the period of under Section 29A, which underwent an amendment in 2019, which said that from the time the pleadings are completed, which means from the time the 6-month period is completed, the arbitral tribunal has 12 months to complete the arbitration and to pass an award. There is a third period, which is where both parties agree that within 12-month period, the arbitral tribunal is unable to pass an award. Parties with consent can extend that period by another 6 months. Then you come to the fourth leg. And in the fourth leg, in spite of all these timelines, the arbitral award could not be passed. Then an application will die before the court, and the court will decide what extension can be granted for delivering the arbitral award, as also the conditions subject to which that extension will be granted, which means that the court can basically say that, all right, I've looked at the facts of the case. I find both parties are not at fault. The arbitrator is also not at fault. For example, take the intervening COVID. I mean, nobody could be faulted for not getting along with an arbitration proceeding during that time. Therefore, I extend the period. I do not impose costs. On the other hand, it appreciates the facts relating to a particular case and says that, yes, possibly the arbitration must be extended, the time must be extended, but I think the claimant and the respondents have not acted with a sense of responsibility. Therefore, I will extend the time, no doubt, but I will extend it by imposing costs to the parties. So these are scenarios that can, therefore, a practitioner of law must understand these 4 parts of time applicable to an arbitration proceeding. And at the cost of repetition, let me assert again. First is 23.4. Please ensure that all your pleadings, because this 23.4 again is sticky business, because there is no judgment. The words used in section 23.4 are the parties shall. I will just read section 23.4. And 23.4 is quite strident in what it asserts and what it mandates, because it says, if all of you have the book, you can take section 23.4. And 23.4, it says a statement of claim and defense under this section shall be completed within a period of 6 months from the date the arbitrator or all the arbitrators, as the case may be, received notice in writing of their appointment. The question is, suppose you don't do that, what follows? 29A, there is a provision for you to go to court and get an extension. 23.4 doesn't make a provision for filing an application for extension. So whom will you file this application for extension? Will you file it before the arbitrator? Will you file it before the court? Who is the authority to decide this application? All these questions remain unanswered in the provisions of the Arbitration Conciliation Act. At some time, it's going to crop up as a major issue with the question of the authority, the person who will decide it, and on what basis will those applications will be taken up and will be decided. These are going to be interesting questions that could going to come up, because this is an amendment that came in 2019. There is no judgment of the Supreme Court on this as yet. But as far as 29A is concerned, there has been a divergence of opinion by High Court. In Rohan Builders India Private Limited versus Rajah Paints India Limited, which is reported in 2023, SEC Online, page 2645, the Calcutta High Court held that you cannot file an application. I told you about the three legs in respect of the arbitration proceeding. The first is 23.4, the second is 29A, first period of 12 months, and then further extension of 6 months. Let's assume all that there is no problem, all that proceeds smoothly, but an application has not been filed after 6 months, but is filed after the 6 month period. Now, if it is going to be filed after the 6 month period, the question arises, can a court entertain an application after the 6 months period? That is 12 months plus 6 months after the extension has been granted, mutually agreed between the parties, and the arbitral tribunal's period has been extended. Can you extend the period? Can the court file an application be filed by the court? Now, this Calcutta High Court comes up with an interesting argument. What it says is, if you look at the 176th Law Commission report, that report said that if after this period arbitration is not completed, then the arbitration proceedings will be taken to be suspended. He did not use the word terminate. However, section 29A uses the word terminate. So since the proceedings have been terminated, there is no power in anybody to revive the proceedings at all. This is a judgment. Against this judgment, there is a appeal pending in the Supreme Court. However, the High Courts of Delhi, Bombay, and Madhya Pradesh have allowed applications even after these applications have been filed after this period of 12 plus 6, 18 months. So this is an interesting question which is going to be decided by the Supreme Court. And I hope at that point of time, the Supreme Court also decides the question as to before whom will an application lie if the pleadings are not completed within the period of 6 months contemplated under section 23.4 of the Arbitration and Completion. So this is something for the practitioners in arbitration law to take note, and to avoid any problem, please kindly ensure that your pleadings are completed within 6 months, and your application for extension of time is filed before expiry of the 6 month period, that is 12 months plus 6 months, which both of you have agreed to. After this period, kindly file an application before the court as a measure of abundant caution. So that is the take home in respect of this set of case laws, which starts from Rohan Builders and the judgments of the Bombay High Court, which took a completely different stand, and the Madhya Pradesh High Court, and several other high courts have taken a different stand. So that is a thing that has to be taken note. As we discussed Section 29A, there is another amendment which has come into the law under Section 29A4, which the Supreme Court had occasion to deal with in Tata Sons Private Limited versus Shiva Industries and Holdings under the amended provisions of the Section 29A. This decision was rendered on 5/1/2023. In this case, this was an international commercial arbitration. In the international commercial arbitration, the arbitration was not completed within the time frames stipulated under Section 29A of the Arbitration and Conciliation Act. An application, therefore, as a measure of abundant caution, because obviously it's only the Supreme Court which can pass any orders with regard to applications in an international arbitration. An application was filed before the Supreme Court for extension of time as a measure of abundant caution. But the Supreme Court said that there is a freshly introduced section in Section 29A1, which makes it very clear that the timelines prescribed under Section 29A are actually only recommendatory in character and are not binding. Because the words used, the proviso to Section 29A1 says, provided that the award in the matter of an international commercial arbitration may be made as expeditiously as possible, and the endeavor may be made to dispose of the matter within a period of 12 months from the date of completion of pleadings under subsection 4 of Section 23. So what the Supreme Court actually said was that the words used after the amendment was that the arbitration may be made as expediently as possible and endeavor may be made to dispose of the matter. So the words being used here are only suggestive and recommendatory. It does not impose hard timelines within which the applications will have to be disposed. So practitioners of law need not strain themselves by filing applications in the Supreme Court with regard to extension of time in international commercial arbitration, because very clearly the timelines there which have been set out in Section 29A on account of the proviso which was introduced in the Act in 2019 are only recommendatory and are not binding. Now we come to the fifth interesting judgment, which is Magic Eye Developers Private Limited versus Green Edge Infrastructure Private Limited, 2023, 8 SEC, page number 50. Now, why is this judgment important? I'll tell you why this is important. For a long time, there has been a question. What must a court decide under Section 11(6) when a request is made to refer the matter to arbitration and when that is contested by the respondent? You could have a very simple situation where the matter is both parties agree, yes, we will refer the matter to arbitration. In which case, the only question before the Supreme Court is, what must be the composition of the arbitral tribunal? Who must head the arbitral tribunal? Who must decide this case? These are the only questions which the court will be engaged with. However, when it is contested by the other party, the contest may be on several different groups. One of it may be the arbitration agreement does not exist at all. Take a case when A and B contract with each other, and that contract agreement between the parties is contained in 3 different agreements to do 3 different parcels of work. And there is an arbitration clause only in one agreement, but there are some stray observations in the second and third agreement which link it to the first agreement. The question is there an arbitration clause in the second and third agreement? What is this question about? This question is about existence of the agreement. The second would be an issue relating to the arbitrability of the dispute. We know that in Vidya Drolia and in several other judgments, the Supreme Court has set out what are arbitrable disputes? There are certain matters which you can't take for arbitration at all. Therefore, in respect of those matters, the matters could not be referred to arbitration. That is the arbitrability of a dispute. Between the existence of an agreement and the arbitrability of the dispute, there is a middle area which is occupied by what are called deadwood issues. There is an existence of an agreement. It is an arbitrable dispute, but let's assume the claim is 30 years old. Somebody has filed a claim, and the cause of action for this claim dates back to some 30 years. He wants that matter referred to arbitration. The Supreme Court said in Vidya introduced the theory of deadwood and cutting off the branches. So it said that in exercise of its powers, it is a discretion vested of the court that when it finds an obviously unsustainable claim being required to be referred to arbitration, it need not send the matter to arbitration. And at that stage itself, it can cut the deadwood and free the issue of any such litigative encumbrance. Now, there are therefore three classes of cases. Now, what has happened in most of the cases is when a section 11.6 application comes up before the court says, I'll appoint an arbitrator, I will send it to arbitration, let the courts decide everything. Supreme Court judgment in Magic Eye developers is a problem for such an approach because the court says that under section 11.6a, and I will read section 11.6a, it says there is a duty cast on the court to decide. So you cannot send it to the arbitrator. This is what the Supreme Court says. And that, since that also, it says, where under an appointment procedure agreed, the appointment shall be made on an application by the party by the arbitral institution designated by the Supreme Court, in the case of international arbitration, or by the High Court, in any other international commercial, as the case may be, the necessary measure, unless the agreement on the appointment procedure provides other means of securing the appointment. So, the Supreme Court, or the case may be, the word substituted. There was an existing 60A which came to be substituted by the 2019 amendment, and this reads, which is very important, please follow this carefully. The Supreme Court, or the case may be the High Court, while considering any application under subsection 4 or subsection 5 or subsection 6, shall, notwithstanding any judgment, decree, or order of any court, confined to the examination of the existence of an arbitration agreement. Therefore, Magic Eye now says that the provisions of section 11.6a cast an obligation on the court before whom a section 11.6 application is moved to refer the matter to arbitration. And if it does not do so, then it is an abdication of its responsibility. The court precisely used these words. At this stage, it is required to be noted that as per the settled position of law, pre-referral jurisdiction of the court under section 11.6 of the arbitration is very narrow and inheres two inquiries. The primary inquiry is about the existence and the validity of an arbitration agreement, which includes an inquiry as to the parties to the agreement and the applicant's privity to the said agreement. That's the first thing. The said matter requires a thorough examination by the referral court. The secondary inquiry that may arise in the reference stage itself with respect to the non-arbitrability of the dispute. For example, if it's a matrimonial matter, and one party claims that both of us have an agreement that any issue relating to our matrimonial relationship can be decided by an arbitrator, court can't give effect to that at all. That is the deadwood theory. Matter relating to trust, Supreme Court has said trusts, especially public trusts, are private issues, and anything that arises under that cannot be sent off to a private adjudicatory forum. So these are deadwood issues. These cannot be sent to arbitration. So far as the first issue, this is what the court says in para 11 of its judgment. So far as the first issue with respect to the existence and the validity of an arbitration agreement is concerned, as the same goes to the root of the matter, the same has to be conclusively decided by the referral court at the referral stage itself. Now, as far as the law laid down by the court in Vidyadrolia, the court at pre-referral stage and while examining the jurisdiction under section 11(6) of the Act may even consider prima facie examining the arbitrability of claims. As observed, prima facie review at the referral stage is to cut the dead wood and trim off the side branches in straightforward cases where dismissal is barefaced and pellucid, when on the facts the law litigation must stop at the first stage. However, now this is very important. Para 12 of that judgment is very important because it says, however, so far as the dispute with respect to the existence and validity of an arbitration agreement is concerned, and when the same is raised at the pre-referral stage, the referral court has to decide the said issue conclusively and finally, and should not leave the said issue to be determined by the arbitral tribunal. The reason is that the issue with respect to the existence and validity of an arbitration agreement goes to the root of the matter. So this again is a very, very important judgment of the Supreme Court, which practitioners of arbitration law have to take note. So with these 5 important developments in the law relating to arbitration, I will end the first part of my presentation on this subject. There are another about 7 or 8 important judgments which practitioners in law need to take note of, and I will do that in the second part of my presentation. Thank you. Any questions? I'm quite happy to answer.
At least on the WhatsApp chat, we don't have on the Zoom, neither on the YouTube. So thank you, sir, for sharing your knowledge. And those who have been connected with us, they will come to know about the second part of this session. And those who have not been connected to us, they can connect us with on the WhatsApp group for the second part by Mr. NL Rajah. And just like today's session, there will be more interesting insights and interesting judgments to be shared. Do stay connected with us. Thank you. And tomorrow we have a session on Guinness by Mr. You join tomorrow at 6 p.m. Thank you. Everyone stay safe, stay blessed.